So now we will talk about contract act. So I have a bare act with you. Let's open contract. So here also when you see section 1, you will remember now this is applicable to whole of India. Right, Dhruv? Yes, Dhruv, am I audible? Okay. So by virtue of which enactment it is applicable? Tell me.
Reorganization Act.
Reorganization Act. Absolutely. So now whenever we do contract, we should all remember that general principles are defined from section 1 till section 75. So we say the gen, general principles are defined in Contract Act from section 1 till 75. So what are these? These are common general principles applicable to all types of. Okay. Now, when I talk about section 1 to 75, let's first talk about the validity of contract. So when you open your Bare Act and you open your uh, table of contents, see, it talks about so validity of contract. It runs from section 1 till section 30. So chapter 2 talks about now chapter 1 talks about communication, acceptance, revocation of proposals. Then chapter 2 talks about contracts, voidable contracts, void agreements, and it is till chapter section 30. So here we will talk about the validity of contract. Then moving further, we have section 31 to 36. 31 to 36 talks about special type of contract where performance is either contingent, that is conditional. Then we talk about sections of 31 to 75 that talks about second type of contracts. Okay. So first let us open our Bare Act and let us go to section 1. Section 1 is clear to you. Now very important, let us talk about section. What is section 2? It is interpretation clause. Interpretation clause means it is a definition. All right. So when I talk about section 2, we see, let us now first and foremost, let us read first section 2 clause H. So what is section 2 clause H? Read.
An agreement enforceable by law is a contract.
Yes. So what it says, whenever we talk about contract, we talk about agreements which are enforceable law. So any agreement by someone to murder somebody, is it enforceable in law? Yes or no?
Uh, No, sir.
Or it is illegal, right? And it is against the provisions of law. So first of all, we should understand that what are the components which makes the agreement enforceable. So whenever I talk about what agreements are enforceable by law, you will remember the 5 conditions. And that is why I say always read section 2 subclause H with section 10 of Indian Contract. So section 2H you will read with Indian Contract Act. Huh? So open up section 10 of the Bare Act and read section 10. What it says?
What agreements are contracts? All agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force, and not hereby expressly repealed, by which any contract is required to be made in writing or in the presence of witnesses, or any law relating to the registration of documents.
So when I talk about the conditions, what are the conditions when we read section 10? The first condition comes is, what are the conditions? It says every
Free
contract is
consent.
an agreement. So first condition is, what is an agreement? So what is agreement? Agreement is defined in section, again,
2 Clause E.
section 2, clause E, right? When we read section 2, clause E, we will also read section 2, clause E with section 2H, comma, as well as section 10. This is the first condition. What is the second condition? That
Made free
is,
consent.
there is free consent. So when I talk about consent is free, I talk about what? Tell me. When I say contract is free, by this I mean what?
It,
Tell me.
it should not be obtained by fraud, misrepresentation, coercion, and undue influence, or bilateral mistake.
Yes. So free consent means I'm talking about section
14.
13 till
30.
section 22. Okay. And it is required by both the parties. Right. So in agreement, there are a lot of questions in the exams also. So second condition was free consent. After that, we talk is the parties are competent to contract. So when I say parties are competent to contract, I talk about section, yes, 11 and 12. Yes or no?
Yes, sir.
Now, moving further, we will talk that their consent is free. We have done section competent to contract. Competent to contract के बाद we will talk about the object is lawful. So object is lawful. When I talk about object is lawful, I talk about section 23 till 30. Yes or no?
Yes, sir.
Yes. So, and last but not the least is expressly declared to be void. So when I talk about expressly declared to be void, where it is now, here I draw my conclusion. Open up section 56 of Indian Contract Act. Open up section 15 of Indian Contract Act.
Yes, sir.
Again, so here, whenever we start contract, we will say start contract. We should always remember what we should remember, that A, we talk about agreement. So we start with section 10. What agreements are lawful? Okay. So section 10 talks about 5 conditions. What are the 5 conditions which I have mentioned, Dhruv? The first is agreement.
Another
That
is
means section 2E, 2H, and section. Second condition was
it should be obtained freely or free consent.
free consent. That is section 13 to 22. Third condition was competent to contract. We talk about section 11 and 12. And fourth condition I discussed with you is what lawful object and lawful consideration, right? So when I talk about lawful object and lawful consideration, I talk about section 23 to 30. And last condition which I have concluded was from that I told you contracts which are not expressly declared to be void. Now, where it is not written in section 10, but when you open section 56, the first line of section 56 says, An agreement to do an act impossible is itself void. So when it is, so, so here it says, which is which says contract doesn't, so it says expressly declared to be, impossible. जो agreement impossible होगा, it is expressly, it will be declared as void. Okay, so this also we cover. Now let us talk about the elements of agreement in it. So first we have to read the meaning of agreement. The agreement is defined, yes, Dhruv, in section, yes,
2
follow.
clause E.
So let us talk about agreement first. So what do you mean by agreement? Read.
Every promise and every set of promises forming the consideration for each other is an agreement.
Agreement, it says, he says every promise, every set of forming the consideration is an agreement, right? So before going further, we should know that what is meaning of who's an offerer and who is an acceptor. So now let us read the meaning of offer from clause 2. So there are two things in contract. Offer and proposal are the same thing, right? And the second is acceptance. Contract tabhi hoga na when offer and acceptance are together, right? So let us know the meaning of offer or proposal, right? So where it is defined in section 2. So what is written in 2A? Yes, read.
When one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal.
Yes. Clear? Achha. So when I talk about proposal and offer, first thing you should remember is a very landmark case was Harvey versus, yes, remember the case? Harvey,
Harvey versus Facey.
Harvey versus. So do you remember that case? What happened in that case? So Harvey versus Facey is your homework. Okay. So you will read this case. And so what happened? So this is a landmark case. Why landmark case? What happened in this case? Yes. Tell me what happened in this case. Hmm. Yes, Dhruv, what happened in this case? You've done contract, not remembered, sir. So now you will read on your own and tell me what happened in this case. Okay? Yes?
Oh,
So Harvey and Vesey is very important case. It is important from prelims point of view. Okay? So why it is important from prelim points of view? Because here the principle of proposal was laid down. Okay? So it said, so whenever I talk about Harvey versus Vesey, you will remember this is a landmark case when we talk about offer and proposal. So in this case, basically, principles relating to proposal were laid down. So it talked about this is a landmark case where there is a difference was told, where you were able to learn what is the difference between invitation to offer and offer. Okay. So here, what happened in this case? Brief facts of the case. I will tell you the gist. So here, there were some articles displayed, and person goes and picks up that article. So it says, I'm offering with the price, it is for sale. He says, no, it is only invitation to offer. So basically, this is a landmark case where we should know the meaning of offer and invitation to offer. Second case which you will do today will be of Balfour versus Balfour. So here, in this case, principles regarding legal obligation were laid down. Third case which will you do today is of Carler versus Carbolic Smoke Ball Company. Here, the principles regarding legal obligation were laid down. So these three cases are very, very important for you, because unless and until you don't read it today, we'll be not able to clear the different aspects and what are the interpretation of these terms. So I'm leaving on you. I'm not going to repeat on this. All right. So moving further, let us talk about acceptance now. So when I talk about acceptance, you should know that, all right. So here, when I talk about these cases, you will note down the important principles in what were held on these cases, all right? And you let me know by tomorrow. So always remember, when I talk about legal obligation now we are doing civil law. So always remember, what is the principle of evidence in civil law? It is preponderance of power. So here you should all remember that, what should be the question put to a poor person. If it says yes, he or she says yes, obviously that will be the the objective test to identify what would that person would have done in that situation. So when I talk about offer, we have two kinds of offer. One is particular offer and one is general offer. So what is a particular offer, Dhruv?
The offer made to a specific person or individuals.
And general offer means it is made to the general.
Public at large.
Now, when I talk about general offer, I will also here mention Section 8 of Indian Contract. Why I'm mentioning Section 8 of Indian Contract Act? Because Section 8 of Indian Contract Act talks about general offer. It says acceptance by performing the missions. Okay. So here I will also do elaborate discussion when I talk about standard form contract. Standard form contracts की भी मैं बात करूंगा. We normally talk about Article 299 of Indian Constitution of India, as well as Section 70 of Indian Contract. So now let us talk about acceptance. So acceptance, whenever I talk about acceptance, so acceptance, when a person accepts or give acceptance, right? So what are the requirements for acceptance? So when I talk about acceptance, I talk about Section 2 Clause B. Read 2 Clause B, Dhruv, of a new contract.
When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A
So always
proposal, when
remember,
accepted, becomes a promise.
Section 2B has to be read with Section 6, Section 7, and Section 8 of Indian. Because these sections will further tell you how the revocation was made, how acceptance can be absolute, and how acceptance can be done by performing. So whenever I read Section 2B of Indian Contract Act, I will read this section with Section 6, Section 7, and Section 8 of Indian Contract. Am I clear on this?
Yes, sir.
So very famous landmark case of acceptance is Feldhaus versus Bentley. So what was the general rule held in this case? It said proposal is not accepted by mere silence of offering. So proposal is not accepted by mere silence of offer. Doesn't assume that if offeree has not said anything, it means automatically means accept. No. Duty to accept. He has duty to speak and accept. All right. Then I will also tell you to read these three cases where these are the circumstances where acceptance can however be inferred. Now these are the exceptions where acceptance can however be inferred by mere silence of offering. But mere silence What are those cases? First, Hyderabad Municipal Corporation's case. Second, Williams versus Cavadine. Third, Lalman Shukla's case. Yes, it's a very landmark case, Lalman Shukla versus Gauridas. So whenever you read Lalman Shukla, you will also try to criticize this case because this case is not followed in other countries, right? So Lalman Shukla, now since you are preparing for the judiciary, you are not preparing for law examination, for your normal law syllabus. Here you need to read the judgment in between the lines, and also this is the landmark judgment because here you have to criticize also this judgment. Because why I say we have to criticize the judgment, because it is against the different accepted notions of contracting various other, like especially in UK. So how this is how we will read Contract Act, and this is the level we have to prepare ourselves for. So all these three cases which I have given you today, you will read on your own. Only then you will be able to understand. And we discuss these cases tomorrow. Next lecture, I'll also talk about revocation, how revocation is made, because it is again one of the important topics for you to understand, right? So when I talk about proposal plus acceptance, that is offer plus acceptance amounts to promise, right? So here you should always, now when I talk about promise, you should always remember to read the last line of section 2B. It says a proposal when accepted becomes a promise. Now, who is a promiser and who is a promisee? See section uh, 2 subsection C. It says the person making the proposal is called the promiser, and the person accepting the proposal is called the promisee. So always remember, when I talk about the valid requirement of valid acceptance, you will read section 7. Section 7 clearly says acceptance must be absolute. Okay? What is section 7 of Indian Contract Act? In order to convert a proposal into promise, the acceptance must first be absolute and unqualified. Second, be expressed in some usual and reasonable manner. Unless the proposal prescribes the manner. Yes, read section 7, clause 2. Dhruv.
Be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which is to be accepted, and the acceptance is not made in such manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in this prescribed manner, and not otherwise. But if he fails to do so, he accepts the acceptance.
Yes. Here you will read the landmark case of Badri Prasad versus State of Madhya Pradesh. Badri Prasad versus State of. Okay. So this is for today. I've given you your homework. You're offline, some are you're online, some are offline also. So I've given you the homework. So in these cases you will read and you update it. Okay.
Okay, sir.